Hi everyone, I'm Jeffrey Marks. I am a real estate attorney. I've been a licensed attorney in Illinois since 2006. I have an office in Arlington Heights, I have an office in Chicago, and I cover the entire Chicagoland metro area, which means that I go south to Kankakee, north to the border, west even past Rockford. Really, if I could go sell houses in the Lake Michigan, I guess I would do that too.
You would do that too.
So yes, I cover everywhere. I charge a flat fee of $500 for any residential closing. That's a real flat fee. There's no extras. I handle commercial transactions as well. I have a full staff of paralegals. I'm always available, even in the evenings, on the weekends, on my cell phone. You can call me, you can text me, you can send me an email. Responsiveness is key. Just a little bit, again, that's about my business, about myself. I'm 50 years old, married, and I grew up in this area. I know this area like the back of my hand. I really enjoy being a real estate attorney. It's been fun. I feel like it's one of the few areas of law where you're actually adding something positive into the world. I did litigation for the first 7 years of my practice, and it was so much fun. It's like playing a video game. It is amazing stuff. But man, you just build misery. It was just, at the end of the day, you had to kind of take a shower, This is fun. At the end of the day, at the end of a closing, people are high-fiving and drinking champagne. Like, this is awesome. I love this. So I really do enjoy this, and I'm really happy that I've built my practice around doing primarily residential real estate. And I do 500 or 600 closings a year. So I'm busy, and I do go to every single purchase closing. None of that BS Zoom stuff. I'm there. I go to every closing, which I think is very, very important, and hopefully helps differentiate me from other people.
I think it differentiates you in a big way from other people. Let's get down to it, though. One of the things I get a lot of questions from, and I'm assuming you are, is the as-is clause that's in the 7.0 contract.
Right.
What does it mean? What does it not mean? What can I get? What can I not do? What can my people do?
So yeah, I think to frame the discussion about the as-is clause, we have to talk about all of the inspection clauses in the contract. And the as-is clause is a big hot button issue right now because I think probably 80% of the contracts I get in now are as-is. And that's because this is a seller's market, right? So in a seller's market, the power shifts, and the buyers to get the transaction approved or get the transaction accepted when they make their offer are pulling out all the stops, and one of those stops is the as-is clause, and that helps make that offer more attractive. So many offers are coming in with the as-is clause, and so I think there's a common misconception about how as-is really works. So I want to talk about that today, and we'll talk about how the regular inspection clause works because I think there's misconceptions about that as well. And really the key here is how to keep these transactions together. So you spent all this time to get an offer accepted, right? And then you don't want to lose the transaction and have it all screwed up immediately because once you've got the offer accepted, you don't follow the rules of the contract or the rules of the transaction. And I often see deals fall apart because of that, right? So I think if you have a better understanding in the beginning of what this stuff actually means, you can then inform your client and then get everybody on the same page, and then make sure that you keep the transaction together, because that's the whole point, right? You don't want to kill a transaction over, demanding that they replace a foil dryer vent or a GFCI, which is, small things, but people lose transactions all the time because they get caught up on these things. Anyway, let's talk about as-is. So as-is is paragraph 36. And then just so you're all aware, the regular inspection provision is paragraph 12. We're going to talk about paragraph 12. We're going to talk about paragraph 36. And we're also going to discuss paragraph 11, which is the inspection waiver provision. Okay? And we're going to talk about how to best draft a contract and get it, to get it accepted, to get the leg up on the competition from all those other agents who are submitting offers on that same deal that your client desperately wants, right? And this is a good trick. So first, let's talk about 36. So I'm going to direct you to paragraph 36 of the contract. So the as-is condition. So I'm going to read this, and I want to make sure that everybody sort of understands what it says, because I think a lot of people read things into this paragraph that don't exist. So the paragraph says, this contract is for the sale and purchase of the real estate in its as-is condition as of the date of offer. Buyer acknowledges that no representations, warranties, or guarantees with respect to the condition of the real estate have been made by seller or seller's designated agent other than those known defects, if any, disclosed by seller. And that's referring to the Illinois disclosure form. Buyer may conduct at buyer's expense such inspections as buyer desires. In that event, seller shall make the real estate available to buyer's inspector at reasonable times. And then I'm going to skip the next sentence. Then I'm going to read the bolded part. In the event that the inspection reveals that the condition of the real estate is unacceptable to buyer, and buyer so notifies seller within 5 business days after date of acceptance, this contract shall be null and void. Buyer's notice shall not include a copy of the inspection report, and buyer shall not be obligated to send the inspection report to seller absent seller's written request for same. Failure of buyer to notify seller or to conduct said inspection operates as a waiver of buyer's right to terminate this contract under this paragraph, and this contract shall remain in full force and effect. Buyer acknowledges that the provisions of paragraph 12 and the warranty provisions of paragraph 3 do not apply to this contract. Nothing in this paragraph shall prohibit the exercise of rights by buyer in paragraph 33 if applicable. Okay, so there's a lot in there, but the one thing that's not in there is that there's no exception for health and safety issues. And that's the biggest misconception that people have, is that, hey, it's as is, but if I find a health and safety issue, I'm allowed to raise it anyway and ask for a credit or for a repair. No, you're not, okay? As soon as you raise any issue, it's the same as saying that the property is not in acceptable condition, which acts to automatically terminate the contract under the terms of this paragraph here, right? So let's say there's a radon issue. Let's say there's a leaking pipe. Let's say there's a small gas leak. Those are things that you'd want to probably raise with the other side, but technically under this paragraph, if you do raise those things, it automatically acts to terminate the contract. So we have to be very, very careful about what we ask for and what we don't. And so I'll oftentimes have a client that's upset. Listen, if there's an active gas leak, I'll let them know, hey, there's a gas leak. This is for your own health and safety, right? But if it's a smaller, let's say it's a radon issue. Nobody wants to move into a house with a radon issue without having it remediated, right? That's normal standard stuff. So what's radon remediation normally cost? $1,500, $1,700, $2,000 maybe? I have to have a talk with a client if their real estate agent has not yet prepared them and explained to them really what they're agreeing to when they go under this paragraph. And I have to say to them, I understand that this is an issue for you. I appreciate you bringing this to my attention, but you have to understand that if I raise this issue, it acts to automatically terminate the contract. And in the meantime, if the seller has gotten a new offer, remember, they can't cancel just due to the purchase price. Remember, that's the one thing that they can't cancel during attorney review. Under paragraph, 10 of the contract. They cannot cancel, you cannot disapprove a contract solely based on the purchase price, right? So if they have another offer waiting in the wings that's maybe a higher offer, but they've agreed to take yours, maybe yours came in first and they accepted it, and now this other backup offer's out there, as soon as you make the mistake of asking for something like a radon remediation, they can terminate immediately and then take that other offer without having any ability for us to sue them for specific performance or record the contract or anything like that. Does that all make sense? So I have to talk to the client, like I was saying, and say to them, is this issue big enough that you're willing to risk this property over, right? Are you willing to walk away from this transaction, from this property, over this issue that's a $1,500 or $2,000 issue? And I try to talk them off the ledge and walk them back so they can make a decision like, maybe it is. Maybe from their perspective, they don't have an extra $2,000. Maybe they're really at the top of their limit, and that $2,000 is everything for them, and they can't go forward without it. Well, maybe at that point we raise the issue because no harm, no foul. What if we lose the deal? We lose the deal, right? They don't care. But you shouldn't be asking for anything unless you're prepared to lose the deal. And I had this conversation with another agent recently, and she told her client that I was overreacting and that it really wasn't that big of a deal. And she convinced after I had convinced the client not to ask for anything, she convinced the client to ask for about $1,500 or $2,000 worth of stuff. And as soon as I sent the letter, 5 minutes later, they canceled. They terminated. And that client was devastated and had to move on to a different property. And, one of the things I talk to clients about, and it's something that I'm sure that you guys say to clients too, is that, each property is unique. When they fell in love with this house enough to make an offer, they have to really think about that house is a unicorn, right? Because that house exists all by itself. Even if they're in Buffalo Grove, or all these houses look the same, each house is still different. It's different enough. It has a different yard. It has different materials inside. It's been decorated a certain way. It has the potential to be a certain thing, and that's different than any other house. Every house is absolutely unique, and they're going to have to go back to the process of looking at houses and making multiple offers and doing all this crazy stuff again if they walk away from this house. And so it's helpful, I think, from my perspective, to remind them why they made the offer in the first place, that they fell in love with this property, that this is something that they've envisioned having a family in, living their life in, and maybe they should step back and really think about if they want to risk losing it over a couple $1,000s. And oftentimes the kinds of things that they're asking me to ask for are way less than a few thousand. They're always asking me to raise GFCI issues, which are what, $50 a piece or something. Like I said, the dryer vent was an earlier example. I'm useless and I can replace a dryer vent. You know what I mean? Like, it's really not that big of a deal. And so, yeah, I understand if they came and said, hey, the roof has to be replaced, right? Or there's a mold issue that's going to take $20,000 to remediate, or there's a structural issue. Again, in that case, great, let's go ahead and raise it. Let's risk, because they don't want the property if these things are not going to get addressed, right? So then we can raise it all the time. I can basically write my attorney review letter in a way that's still polite, that raises all my regular attorney review issues, and then at the bottom I'll say, my client conducted an inspection pursuant to paragraph 36 of the contract. We find the property to not be in acceptable condition. Notwithstanding such, my client would be willing to proceed forward if the seller agrees to provide a $10,000 credit for roof repair, or if the seller agrees to replace the furnace, or whatever it is that we're asking for. And then the client knows we're asking for this thing. They understand that there's a risk that the contract will not go forward. We're putting that right on the table that the contract is not as an acceptable condition, because we want to make sure to protect the client, right? Because if we just ask for something, the other side may say that we've even waived the provision. So we want to be specific that we can still walk away, right? And we put it all in writing and send it to the other side. And hopefully at the same time while I'm doing that, you guys as brokers are trying to negotiate the same with the other broker. And that's really, really important. Oftentimes too, before I write a letter like this, I will say, hey, before I send anything out, you realtor, contact the other realtor and see if you can work something out. See if they'd be willing to provide a credit. See if they understand that this is an issue that they're willing to put some money behind. And oftentimes they will agree, yes, we understand, we're expecting you to ask for something, we have no problem with it. And then we can do it with very little risk. Of course, they still have the opportunity to terminate, but I can write my letter differently. I can say in my letter, instead of asking for a credit, I can say, the parties have discussed this issue and have agreed to provide a credit of X amount of dollars. And then I think that it's not the same as saying that the property is in unacceptable condition. What we're just saying is that there's another agreement to provide a credit. And that works too, and helps protect the client. And you had a question?
Yes, the client, the agent we worked with recently, who took it upon herself to tell their client, but don't worry what he's telling you, listen to me almost. Weren't they acting as an attorney at that point? And that's
No.
Jan, let me repeat this so we get it on tape. The question is, when agents are giving it advice that may contradict what the attorney is giving them, are they taking on the role then of being an attorney as well?
No. It's kind of a weird thing that we as attorneys do in this area. Interpreting the contract would be legal advice. Drafting the deed would be legal work. Negotiating is probably not. And advising the client about negotiations, again, is probably not. And it's important that the client hears multiple voices in the transaction, right? My job is to always give the client the worst case scenario so that they understand what their ultimate risk is for whatever decision they're going to make. And then it's up to the client to make that decision. And it may be a good time after I've given them the gloom and doom and let them know this is what could happen, for an agent to step in and say, just so you know, Jeff's absolutely right, but I've done a bunch of transactions, I've talked to this broker, that broker knows me, I've already kind of discussed this issue with them, and in this case, I don't think that this is likely to happen. And so a broker could step in and say something like that. Of course, if it turns around and blows up in your face, then it's dangerous for you. You've lost the trust of that client. And that's what happened in this case. There was a degradation of the relationship between that client and the broker, because the broker kind of talked her into something that originally she didn't want to do. But it's the worst case scenario. In the worst case scenario, maybe it happens 1 out of 25 times or 50 times or whatever, but it still happens. And so that's why we always have to let the client know, here, this is the potential risk of you going down this path. And even if that risk may not really manifest, it's still out there.
Yeah, but in the market we're in right now, it's unprecedented. We've never seen a market like this before, really, as far as the way it's going with multiple offers, 20,000 over asking list and all that. I mean, I would think what you'd want to be doing is helping your client make the best decision possible and referring to the attorney. I don't know, I'm just saying.
I would agree with you. And so what she just said was that in this kind of a crazy market, you would think that the broker would want to step back and not push those types of things because the market doesn't really support that, and maybe just listen to the attorney. And that's true, but you guys are going to know the market better than the attorney, right? Because you're out there on the streets, showing properties and talking to buyers and sellers. We're kind of in a smaller pocket. We talk to our clients, but we don't know what's really out there. And so I often defer to the broker to get their opinion. Yes, we're in a weird market. It's unprecedented what's happening. And I would think personally that just getting the transaction over the finish line is the most important thing, and we shouldn't worry about these little things. But, listen, real estate agents, unlike us as attorneys, you develop these relationships with these clients. You become their friends. You try to protect them. And, I think oftentimes the real estate agents get caught up in saying, hey, this isn't right. They knew about this issue. There's this issue in this house. They should fix it. My client shouldn't have to deal with this. And they sort of push that, even if it's a minor thing that doesn't cost a lot of money. And it's a mistake. You shouldn't get emotionally involved like that. Because I think it actually does your client a disservice because you get hung up on things. And I think that's probably what happened in this case. And it does happen quite a bit. But I think that as much as you want to be protective like that of your client, you also have to understand that really what you're trying to do is get them into a house.
Yeah, you want to win the bet. You want to win the war, not the battle.
100%.
And that's what they were looking to do. They were looking to win a battle, not the war. They got them this far. They've been maybe missed on multiple other offers for whatever reason, and here they've got an offer. It's this close, and just the whole thing blew up.
Correct. Yes.
Because of that.
Yeah, there's no reason a deal should fall apart once the contract's been executed and everybody's accepted it. Right. As long as there's not a significant inspection issue, right? There's no reason ever. Yes, your question.
Speaking of an issue, is this if someone comes back and says there's a structural issue, inspection showed a structural issue, is the seller obligated to reveal that to their next buyer?
It depends. So the notice provisions are a little bit odd, right? Me just telling somebody, hey, there's a structural issue is not enough. They have to, or the broker saying it, they have to actually be put on notice. They have to really see that, or they have to get the report in hand that shows proof of it for them to be on notice, or else it's just somebody's opinion. Is it better to disclose? Yes. Am I always dismayed when somebody asks for a copy of the inspection report when I'm representing a buyer and the seller asks for it? I can't believe that an attorney would, I think it's malpractice personally, asking for a copy of the inspection report because it puts the client on actual notice of all the defects that are found in that inspection report. You don't ever want to do that. So structural issues are an interesting topic because structural issues are the kind of thing that would kill a contract even under as is because you have an unknown amount of damages to the property or the repairs. But the cool thing about the as is provision, as if you remember when I read it, it replaces paragraph 12. It is the inspection provision. So I know it says the as is provision. It really should say the as is inspection provision. It should be retitled because it really is an inspection provision. You're allowed to do any amount of inspections just like you would under a normal transaction that proceeded without the as is under paragraph 12, which is really cool because if there is a structural issue, you can go out. Let's say the inspector says, hey, I believe there may be a structural issue here, because they're never going to say that there is one, right? So then you hire a structural engineer to come out. You're allowed to do additional inspections. You're allowed to ask for extensions, just like you would under the normal inspection provision. They don't have to agree, but you can ask for it. And then you can get an idea of what something's going to cost. Just because there's a structural issue doesn't mean that it can't be repaired for an inexpensive amount. It may be that you could repair it for a few $1,000s or something like that. Not every structural issue is a $50,000 or $60,000 issue, although a lot of them are. But that way you can make the determination, again, at least make an educated decision whether or not, the buyer can make an educated decision whether or not they want to really proceed forward or not. You don't just want to do an initial inspection and then just run away because of a potential issue. It's the same thing with mold. Oftentimes the inspector says, hey, I believe there's a mold-like substance, but who knows what it really is? It could be mildew, it could be anything. And it could be very easy to get rid of and not expensive. So it may be worthwhile continuing forward even with an issue like that. I think the real issue that I see where people run away no matter what is if they see something like a vermiculite or, something that you just know is going to be just a nightmare to resolve. And then they don't usually do additional inspections. So let's talk then a little bit more about how this interacts with paragraph 12. So remember the last sentence here says, buyer acknowledges that the provisions of paragraph 12 and the warranty provisions of paragraph 3 do not apply to this contract. So paragraph 12 is the normal inspection provision, right? That's gone. You put an X through that. It literally doesn't exist in the contract if you have paragraph 36 initialed. But more important than this, and this is a really key thing that I want you guys to take away from this, is that it also removes the warranty provisions of paragraph 3. So the warranty provisions of paragraph 3 are on the first page of the contract. It's lines 31 and 32. It says, seller warrants to buyer that all fixtures, systems, and personal property included in this contract shall be in operating condition at possession. That's gone. So as is removes that. Right now, again, the house has to be in the same condition that it was in at the time of the original offer, right? That's what the as is provision says. But then the other portions of the contract talk about that the house has to be in the same condition, normal wear and tear accepted. So if something stops working, and that's normal wear and tear, then they don't warrant that it's going to work. So they can check all these different things. So normally on the contract, when you check all these boxes under paragraph 3, those things all have to be working at the time of closing. But under the as-is provision, if they stop working through normal wear and tear, or they were never working even at the time of the original contracting, let's say the humidifier that everybody has in their house that doesn't work, it does not have to be working at the time of closing. So that's detrimental to the client. So the client's giving up something very big. Those warranty provisions are very important because that's what the whole walkthrough is all about, right? It's not just about looking for water in the basement. It's turning on every light switch and turning on the stove and running a load in the dishwasher or in the washing machine or whatever people do when they do their walkthrough to make sure everything's working. So there's I think, an interesting thing that you can do to get away from this issue and better protect the client. Now, this is not for everybody, and I'm going to warn you that you have to be very cautious about doing this. I'm also going to warn you that if you're going to do this, you need to talk to your managing broker, make sure your brokerage allows this, and most brokerages will have a form or something that you're going to have the client sign if you're going to go down this path. What I'm talking about is paragraph 11 of the contract. So paragraph 11 is the waiver of inspection paragraph. And you're going to hear people saying you should never have a client waive that inspection. Because if they waive that inspection, there's a lot of liability. And yes, there is. And I predicated this by saying that this is not for every client. This is for certain types of clients. If you have investor clients or clients that have bought multiple properties over the years and they understand the risks of buying a property. Paragraph 11 says, buyer acknowledges the right to conduct inspections of the real estate and hereby waives the right to conduct any such inspection of the real estate and further agrees that the provisions of paragraph 12 shall not apply. So again, this removes paragraph 12. There is no inspection paragraph now, right? But if you noticed, it doesn't remove the warranty provisions of paragraph 3. So here's the trick, right? If you don't initial as is, if you just initial paragraph 11 and you waive the inspection, when you do your walkthrough, every single piece of personal property and all systems of the house have to be in operating condition at the time of closing. So you don't give up anything except for the right to do that initial inspection. This is incredibly powerful because when you make an offer and you say to you're going to submit your offer and you say, hey, listen, my client, we're just going to waive our inspection. that is a very persuasive offer. It's an enticing offer to that seller, right? Because you're going to waive your inspection. You're not going to check paragraph 36. You're not going to say, I'm going to waive the inspection and make it as is. That's the last thing you want to do. What you're going to do is just initial paragraph 11 and submit that offer. And that offer, in my opinion, I think, to most real estate agents and most sellers, is going to look much more attractive than even an as-is offer, because they're not really thinking about how all this stuff interacts. Maybe when they watch this video, they will. But until then, most people don't really think about this. So that paragraph is actually better for your client, because at the time of your walkthrough, at the end, if there's anything that's not working at all, that's in this checklist or any of the systems that are contained within paragraph 3, those things, they have to be in operating condition at the time of closing. They don't have to be working perfectly, but they have to be in operating condition at the time of closing. So
I have a question then. When you get to the closing table, are people surprised by this difference?
they get raised prior to the closing table typically. Okay. So the people who are using this are typically people that I've trained, that I've talked to about this, and they know that they need to get me involved as soon as they see an issue, and then I let the other side know. And yeah, they have to get it resolved.
Okay.
But they're not happy about it. I mean, I don't think they're expecting it.
That's the question I'm
asking.
asking.
But now we're at the day of closing. So, I mean, they want their money. You know, they're packed up. They're moving.
They have a high desire to close.
Yeah, they're in their moving van. You know, they're waiting for their other place to close, and all of a sudden now they have to replace a refrigerator. That's awesome. I mean, it's great. What was your question?
It's a little dangerous to me.
It is, yes.
Because at the walkthrough, yeah, it's right before the closing. You know, who's running the dishwasher the day before? Who's running the wash machine and the dryer? Like what you would do in the inspection. So I wouldn't want my buyer client to. I wouldn't want to make them nervous like that the day before the closing that they waived. I would be saying, Attorney Jeff said, like, I would just never.
I agree, and it's not for everybody,
Yeah.
but
like you said,
it's arguably still better.
An investor or something like
Right,
that is different.
100%.
Yeah.
But at least in my opinion, if this is somebody who's buying maybe their third house, not for a first-time home buyer, for sure, but if somebody understands what it is to buy a house and what it means, and they understand they're not buying a new house, they understand there's going to be work involved, I think that, you know, you do, when they initially walk through the house before they make their offer, they take a really hard look at everything, and then you know, you have them, when they do their walkthrough right before closing, you do it at least the day before, if not 2 days before, and you make sure they literally turn on every light and test everything in the house, almost like it was an inspection. And you're not going to have the benefit of having an actual inspector with you, but you know, it's most of the stuff is hopefully relatively obvious, the big issues, right? They can run the AC, they can run the furnace, they can, you know, do all those things. And yeah, you know, it's a really powerful provision. I don't know if this is going to get cleaned up when the 8.0 comes out, but right now it's a nice little loophole that everybody should be taking advantage of if you have the right type of client. Again, listen, I know that certain real estate offices have been sued over this provision by clients who have waived the inspection provision because their broker told them that they should do that. The realtor said this is a good idea, and then the house was a money pit, and then they filed a lawsuit. So the one thing that you have to do is make sure that they sign a waiver that says that they understand that they're giving up this right, and that they understand that they're solely responsible for any issues that are found, and it's not your fault, the brokerage's fault, the attorney's fault, anyone else's fault. Again, it's just a negotiating tactic. It's a way to get your contract accepted. And if that gets them in the door when something else wouldn't, if that saves them from making an offer that's $10,000 over or $20,000 over, they've just made their money back right there, even if they have to put $10,000 in. They got the contract. They got the property. Any more questions about this?
I have a question. What you're talking about is also, it seems to me, somewhat market specific. This might not be the same advice you would give it if it was a seller's market or a buyer's market.
100%.
As opposed to a seller's market.
No, there's been times where I've literally gone for months and months and not seen an as-is contract.
Right.
And you know, because the way the market is now, almost every contract's an as-is contract. And then let me also point out that the as-is provision, by the way, does not remove the requirements for the seller to perform a well and septic evaluation and to make repairs to the well and septic. It specifically carves out in the as-is provision that it does not impact or affect that provision of the contract if that provision has been initialed. But again, if you're going to go under paragraph 11, do not initial paragraph 36, because then now you've given up all your rights. You've given up the right to do the inspection, and now you've given up those warranty provisions. So you definitely do not want to initial both sections. That's bad. That's a big no-no. That's the worst case scenario.
All right, so my next question then, Jeffrey, would be, okay, I think we're seeing tons of this as-is nonsense.
Right.
That's what I'm hearing over and over again, lots and lots of this. What's the next thing that you're hearing a lot about?
Well, I think that there's a couple major issues that are impacting people right now that people are confused about. I think that there's been a lot of lender delays on transactions lately. I think that you have to prepare your clients, both the buyer and the seller have to prepare your clients when there's a transaction where there's a lender involved, that it may not close on the date of the closing. And I've seen a lot of transactions that almost blow up because the seller gets personally insulted that the transaction is going to get delayed by 2 or 3 days or 4 days or a week or whatever it is. It's usually not a significant amount of time, but because of TRID and disclosure rules, sometimes the closing just can't take place on the date that the contract is set for. And we try as attorneys, we understand that. I don't think we as attorneys take offense to that, but I think sometimes the clients do if they're not prepared. So I think it's really important to let your clients know that the closing date is more of a goal than a set date. And I understand they want to set their plans. They want to get movers. They want to do these different things. You should tell them that, number one, prepare them to understand that there's a contingency. The mortgage contingency typically runs until 5 business days before the closing, which is a week before the closing. So, there's still an unknown even a week before the closing. But once we get past that, they should be prepared, very quickly to figure out how to move. And even if that means that they have to temporarily keep their stuff on a truck or in a pod or in storage, because they're scrambling a little bit, that may be the solution. And unfortunately, I wish it was better. I wish, we all had that set date and that date never changed. But I'd say it's more often than not that the files don't close when they're supposed to close.
Okay. The other thing that I'm hearing is that we have a lot of deals that are falling apart these days, that are just playing
Yes.
a much higher percentage than usual.
Yeah, and I think that's because of the inventory. So you have less inventory on the market, so you have people making offers on things because they have to move, but they're properties that they are not really in love with. They're settling, and I think that at some point during those transactions, they realize, wait a minute, I really shouldn't be buying this. I'm going to be, once I'm in a house, how long does it take to be in a property before you can turn around and sell it and even break even with all the costs that are involved in the closing? So they have to really be committed to live in this property for a period of time. And I think that at some point during the transaction, they realize, wait a minute, I shouldn't be going forward. So that's where I see a lot of deals falling apart. And it's usually, again, people settling for properties they don't really want. But there's also a lot of deals fall apart, I think, because of the inspection provision. And even if somebody's proceeding under the regular inspection provision, under paragraph 12, I'd like to remind them that they made this is what I say. I say that the property was listed at a price based on its current condition. And they made an offer on the property based on its current condition. And that any issues that they found are, the part of that property's condition. And if they want to ask for anything, to be repaired or for a credit, they're actually making a counter offer. They're opening back up the contract and telling that person, the seller, hey, I don't think your house is really worth $350,000 in its current condition. I think it's worth $340,000, which is why I'm asking you to give me a $10,000 credit, right?
Right.
So that often causes transactions to fall apart. I have that same, again, I tell the client, listen, I understand you're allowed to ask for things, but you understand now that you're opening the contract back up to ask for things, the other side can turn around and try to cancel if we can't come to an agreement. So it may be in your best interest to think about what issues are so big in your mind that, again, if they didn't agree to it, you wouldn't want the house. So that at least typically gets rid of all the really minor stuff. I remind them that paragraph 12 talks about things that are allowed to be asked for and things that are not allowed to be asked for. Again, and I think that's something that you as realtors don't often, well, maybe it's not that you're not explaining it, but I think the clients don't really understand it. So again, like things like cosmetic issues can't be raised under paragraph 12. Things that are minor in nature, maintenance issues. So oftentimes people will come to me and they'll say, Jeff, I want them to have the furnace cleaned. You can't. You can't have the furnace cleaned. That's a maintenance issue. Or, hey, Jeff, there's a crack in the drywall, or there's the way that they painted this room, I don't like it, or there's some old water damage, that's caused the paint, to look weird. Those are things that we can't ask for, right? And so I try to walk them off of that, and then really just raise the things that are so important to them. Like let's say they need to have there's been water in the basement, so they want to have Permaseal come, do some work, or they're looking for a credit for the roof, or the air conditioner is not working correctly, or the furnace isn't working correctly. Those are big ticket items that are worth perhaps risking that transaction. But again, they have to always understand that once they make, and the contract's very specific about it. It does label these things as counteroffers. Once you make that counteroffer, you're opening the contract back up, and you want to try to avoid doing that if they really love the house. And I think it's important that you let the client know that too, that when they're viewing this property and the price that it's listed at is based on its current condition, because I think a lot of people just believe that anything that's wrong they're entitled to ask for, but really it's still negotiation.
They're not, but they're not.
I mean, the contract allows them to maybe, but maybe they shouldn't be.
I tell people to remember, you're buying a used house.
Right, 100%.
You're buying a used house. You're not buying a new house, you are buying a used house. That's hard for people to take to their heart, especially if they love it.
Right.
That's hard for them to really grab hold of.
Right.
Because to them it is a new house.
Right.
No, but it's 55 years old, so it's not so new anymore.
Right, and it may have, some, old fuses, or it may have, it may not have GFCIs. It may not have the bibs on the outside that, are frost-free or whatever, these things that modern houses will have. But, those things are all generally small things. And if they can figure out a way to budget to change these things
Yes.
over the, first 5 years that they're going to own the house, that's way better than them, asking for a million things up front and then losing the transaction, because then they won't get that house.
Well,
and every house is going to have a problem.
Every house. The people next door to me, my house is 70 years old. The people next door to me, their house is a little older than that, and they put additions on. So when the new young couple bought the house, good thing he's a handy fella.
Yeah.
That's what I'm going to say. Because at one point, over the back fence, he's telling my husband how, well, in one part of the house, they found old knob and tube wiring.
Right.
And I thought, that's interesting, knob and tube wire. He said, no, we're taking it out. Don't worry, we're not going to burn the house down. We're taking it out. But it was just, the house was, even though I know that they had an inspection, it still was full of surprises to them.
Right.
As they started pulling things out and cabinets out and knocking walls down and doing that sort of stuff.
Right.
There were always, that's I think another thing to remind your people. When you move into a house, an older house, there's always a surprise there.
Oh, 100%. And they need to budget for that. And that's a
Yes.
problem too, is that sometimes the clients will go to the top of their budget and they'll really spend all of their income on this house, or all their savings on this house, and then they don't have the money to fix these things. And when somebody says to me, hey, I'm buying this house, and let's say we're under the as-is provision, and there's a radon issue, and they say, well, I don't have the $2,000 to get the radon remediated, then I think that maybe they should not be buying that house, because that's going to be the least of their worries. I think about all the things that happen, in places that I've lived over the years, and things happen. You have to fix them.
The home warranty people will always tell you, the dishwasher worked the day of closing, but 2 days later when they moved in, the dishwasher does not work. Well, somebody did something and somebody owes me something. I mean, it's
Yes.
just the nature of, again, what I also say is, well, welcome to home ownership.
Well, every time there's one of those huge rains, the next day I get a phone call.
Yes.
There's water in the basement. What do I
course.
do?
Yeah.
And I'm like, you get it fixed.
Clean it up.
you get a mop and a shop vac. Yes. Very rarely have I had, over the years, I've had anyone successfully be able to file an action against somebody for violations of the disclosure rules.
That's actually a question I get pretty often in class. Okay, my basement flooded the next day, or my dishwasher didn't work, and blah, 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 and I'm mad at the agent, and I'm mad at God, and I'm mad at everybody on the planet Earth. they want to sue somebody, but what you're saying
Right.
is it doesn't work so well.
It doesn't work so well because you have to prove that they had actual knowledge of this issue and they hadn't made good faith efforts to repair it and think that it was repaired. So if somebody does have water issues in the basement and then they've hired somebody to come make the repair and then they don't have it again until the closing and then the day after the closing, it explodes up, you can't go after them.
Right.
And even if you had an inkling, you thought that they knew about it and you thought that they hid it, how are you going to prove that they did
Exactly.
that? So I've had it twice in my career where they've been able to prove it. And once because there was a bunch of holes in the basement walls that were hidden behind posters that they left up.
Well, pretty obvious.
That was pretty obvious, right? Yeah. So, and then the next one was there was the house. It was one of those lofts in the cities with all the exposed brick that are so beautiful. And the guy moved in, and the mud or whatever that mortar was like falling down like snowflakes, right? And so he called a guy. He asked the building. It was a condo. So he called the association. They referred him to somebody. The guy came and he's like, "Oh, I was in this property." He goes, "Yeah, I did a repair." And he goes, "Well, what happened?" He goes, "Well, I told the guy he had to have this all replaced. It was going to be like $15,000." But he said, "Well, do you have just a quick stopgap measure?" And I said, "Yeah, I can do a quick thing that'll last a little bit. It'll be like $900."
Yeah.
And so that's what he did. And so then we were able to go back. And, we had his testimony, so that was easy.
Testimony, yes.
But I mean, I've had probably 200 phone calls with issues over the years on this, and that's the only two that have actually, worked out.
It's very hard to prove.
It's very, very hard to
And
prove.
sometimes it really is just the nature of home ownership.
Yeah.
Sometimes you move in and stuff goes bad.
And the best thing that you can do is make sure you do a walkthrough. Don't ever waive the walkthrough because maybe you'll catch an issue during the walkthrough. Make sure if a client says to you as a real estate agent, "Hey, I don't need to do a walkthrough," or "You do the walkthrough for me," don't ever do that. Insist on them doing the walkthrough. I'd even say if they're not going to do a walkthrough, probably have them sign a waiver because there's all kinds of issues that can come up. I had a transaction early in my career where the broker was a dual agent, and she told her client, the buyer, that she didn't need to do a walkthrough. Everything was fine. And then after the closing, she went to the property, and the basement had like 8 feet of water in it.
Oh, yeah, that's bad.
And the client was obviously upset. And I talked to the other attorney, and so the seller and the buyer both filed claims on their insurance, and both insurance companies denied the claim. And they denied the claim on the basis that they couldn't tell when the issue happened. So the seller's insurance company said this could have happened after the closing. The buyer's insurance company said this could have happened prior to the closing. So neither of them would pay the claim, and they're both stuck. The client was stuck. They didn't have any compensation for the issue. And if she had just done a walkthrough, they would have seen it.
So Attorney Marks, I have another question. You brought up a phrase that is always interesting to me, and that's dual agency.
Yeah. Well,
Okay, you don't need to say any more then.
I wish it was made illegal. I mean, as attorneys, we're not allowed to represent multiple parties, especially parties that are adverse. We even get kind of touchy when let's say we're representing a couple that's divorcing. I can represent both of them because they have a common interest, but they may not exactly be on the same page. I would never represent two opposing parties. I would lose my license for doing so. Mm-hmm. I don't understand why the state makes it legal for real estate agents to do so. I think it does the client a huge disservice, both clients, because you can't advocate for them. You lose the ability to advocate for them the way you would for a normal client. And what's the point of having you? I mean, listen, anyone can go into Realtor.com and look at properties. You guys add that personal touch, that the ability to advocate and negotiate and your knowledge all to the transaction. That's what makes real estate agents incredibly valuable and special. And when you go dual agency, I think you give up a lot of that. And I don't understand why it's allowed. And I think it causes more harm than good.
Okay. Something else I've noticed as I've been listening to you talk is you talk to your clients a lot.
I do.
You do. I don't know if that's typical for attorneys to talk to and you talk to them.
I do.
Not your assistants, and sometimes it's
well, of course they call my assistants if I'm busy, or the assistant may call them to schedule the closing or something.
Right.
But yeah, no, I have substantive talks with all my clients.
With all your clients, and I'm not sure that all attorneys do.
All I can tell you is I do things a little bit differently, and the reason is because I didn't go right from high school to college to law school to practicing. I worked in the real world. I was a video game designer and producer for like 10 years before I decided to go to law school and give that up. And I worked with attorneys, and I hated working with attorneys. I felt like attorneys weren't listening to me. They were charging me $1 million to just, answer a quick phone call. and they were at 5 o'clock. If it was 5:05, good luck getting any advice.
Okay.
And they just weren't responsive generally, and I hated it. So when I built my law firm, I wanted to do things differently. I really thought about what's going to be best for the customer, the client, and really provide customer service, responsiveness, talking to them in a way that they'd understand. Don't talk down to them. Don't make it about myself. Make it about them. And that's my philosophy, and that's why I think I've done a really good job and why I've been successful in this industry.
Okay. I'm not sure, as I said, I'm not sure that all attorneys who do real estate closings feel quite as compelled to actually chat with their clients as much as you're doing.
I do, and it's funny because people talk about my shoes, right?
I don't know if you all noticed the shoes. Will you just give us a little lowdown on what you're wearing today?
So I'm wearing my spiky red Louboutin shoes
Yes.
that are covered in red spikes. So it's an icebreaker. When I go to the closing and I'm wearing these, and wear my skull ring or whatever, it's an icebreaker. It's an easy way to cut the tension, make them feel comfortable, make a joke. I make self-deprecating jokes all the time. Put them at ease, and then make sure that they feel comfortable. And I don't want to be the guy at the closing who's talking at them. I have a conversation with them. I make it interactive. I make them laugh. I make sure that they really understand. I try to explain things to them, like the mortgage, for example, which is this 13, 14-page document that's incredibly confusing. I try to lay it bare so that they really understand in layman's terms what it means, what they're signing. And that's really important to me. And that's why I've gotten good reviews, is because people feel comfortable with me. Now, some people may want that more formal relationship. That's what they think an attorney is supposed to be. That's not how I want to practice law. And I think that I can be friendly and have a humorous attitude, and still be serious and still be a bulldog when I have to be, and still do a really good job and protect them legally. And I've never really had any issues. I've never had any malpractice issues. I've never really had any significant issues with clients. Everybody's happy.
Clients like you.
I hope so.
I do.
Yes.
That's what I'm going to guess. And I've been thinking lately a lot about this whole idea in real estate of likability. Your clients have to know you and trust you, but they also kind of have to like you. So I've been thinking about that, and you have that characteristic, that likability characteristic, from your shoes to your ring, which I'm sitting here admiring. Some of you should take a look at it. It's fabulous.
Thank you.
Does anybody we have a few minutes left. Any other questions?
Hi, it's very good presentation. Thank you so much.
You're welcome.
So my question is that, so when we purchase house as is, and most of the time it's investors, right? Can an investor use his own sales and purchase agreement?
Okay, so the question is, can an investor use their own sales and purchase agreement? The answer is yes, but they shouldn't generally, because they're usually terrible. So when I have investors who take these classes and they come to me with their own agreements, I almost always talk them out of using them because they're awful. They don't really protect them. They don't talk about things like apportioning certain costs in the closings. They're very generic typically and not used for the state of Illinois. They're usually for, be good in any state, so they don't really have things that are important here in the way the law works in the state of Illinois for a real estate transaction. I generally don't like them. That being said, sometimes they have good contracts that they've developed over time, depends on what their experience is. But I have a client who's an investor client who's probably bought, in the last, let's say, like 4 or 5 years, he's probably bought like 200 properties. So, and he's probably sold 100. So he does a lot of transactions. He uses the 7.0, and I like the 7.0 a lot. I actively dislike the car contract. I really like this contract. I do make changes to it. I mean, I have sort of a generic attorney review letter with provisions that I take in, take out, depending on the transaction. But it's typically like 20 paragraphs of requests that I think that there's some holes here. Like there's no appraisal contingency contained within the 7.0, which is a huge problem. So we always have to ask for it. We have to explain to clients what that means. Clients get upset about it on the sales side. But again, there's just things about this contract, like you don't have to disclose if there's been any insurance claims. You don't have to disclose if there's ever been any water issues. Those are things that are important, and I think buyers need to know. There are holes in this contract, but it's still better than the alternative. And it's definitely better than those like 1 or 2 page investor contracts that you see. And I think the people who use those unless there's a very compelling reason to, are generally foolish. Yeah.
Anybody else?
Are you
Yes.
seeing more appraisal waivers?
I have been. And I'm wondering why. I wonder if it's because we're still in a market that's increasing in value, and these lenders are afraid that if they don't do an appraisal waiver, that they may underappraise, and so it stops. Because that's what usually happens when a market moves up, is that they're looking at the historic prices, and so appraisals tend to come in lower, right? And so maybe that's why it's happening, or maybe it's just the way that the regulations have changed. I'm not really sure, but I have been seeing quite a few, and it's a great thing. Although I have seen clients get angry. I did a transaction up on the North Shore once where the client did have an appraisal waiver, and they made an offer on the property. They bought the property. Appraisal waiver closed, and then I think maybe 6 or 8 months later they decided to refinance, and then they did get an appraisal, and it appraised significantly under the purchase price. And they were livid with the real estate agent, saying that, hey, you should have told me it wasn't worth this. You neglected your duties, all this other stuff. And they were mad at me too. Not that really the agent or me had anything to do with it. They were the ones who chose and agreed to have the appraisal waiver. We don't have anything to do with that. But I guess there can be some consequences to waiving the appraisal too.
One last question.
How big of a deal, the 5-day window makes people very nervous. How big of a deal is to get it an attorney review extension?
Again, well, it's not a big deal. I ask for extensions all the time. Generally, as long as it's the one extension, the other side doesn't care, although they can cancel the contract over it. It's not common, but it can happen. The 5-day window is not to complete attorney review, and I think that's, again, another popular misconception. It's just to begin attorney review. So the letter has to go out before the end of business on the 5th day. Once the letter goes out on that 5th day, there's a 5-day cooling off period where neither party can unilaterally terminate the contract. After the second 5-day period, now we're at the 10th business day after acceptance, then either party can terminate the contract if they're not in agreement. The cooling off period is actually really a great thing. It was made more explicit in the 7.0. The 6 point whatever it was that we had before this was a little muddy. But during that 5-day cooling off period, neither party can unilaterally terminate, which means that if I've asked for inspection issues and they've maybe said no to them, I can withdraw them. If we're getting to the end of the 10 days and we still haven't gotten a response, and we think maybe what they're doing is purposely trying to wait out the 10-day time period so that they can terminate the contract, maybe because they've gotten a better offer or something, we can withdraw even the attorney review questions or the attorney review requests that we've made and basically say we're taking the contract in its condition that it was, and then they don't have an ability to terminate. So that second 5-day period after attorney review begins is really important. But yes, so yeah, I generally, as a rule, don't send out my letter until the 5th day. I know some real estate agents don't like that because they want to try to get a hop on it, and I don't mind doing it early if the agent asks me to, but I like having that extra time for the client to really make sure that they want to go forward, that they haven't made a bad decision. I always talk to the client on that 5th day and make sure that they still want to go forward, that double check with any issues that they may have, or talk about the inspection, whatever it is that we're going to talk about, and then I send out the letter. And then usually we resolve attorney review within a couple days after that, and then we formally close it. But as long as the letter goes out by the 5th day, it doesn't close until the parties agree to close it.
Jeffrey, I'm going to thank you very much. This has been again, as is stuff is the questions I get most if I'm teaching core classes
Yes.
or basic classes, contract classes. Again and again, they ask these same questions. Thank you for your time. We enjoyed having you here very much.
It's my pleasure. Thanks, everybody.
The views and opinions expressed by this presenter are theirs. They may not reflect the views of North Shore-Barrington Association of Realtors.